Good afternoon, everybody. Good afternoon. Welcome to Case Western's Law School. Welcome to the Baker Hostetler Moot Courtroom. As a alum of this law school, it is my pleasure to introduce Professor Jonathan Adler. Professor Adler is the Johann Verheij Memorial Professor of Law and the Director for the Center of Business Law and Regulation. The Johann Verheij Memorial Professorship was endowed by Richard Verheij, class of 1983. Professor Adler has his BA from Yale University, his JD from George Mason School of Law, and he is a contributing editor to the National Review Online and a regular contributor to, as many of you probably know, a column on the Washington Post. He's a regular commenter on constitutional and regulatory issues. He has appeared on numerous radio and TV programs, ranging from the PBS NewsHour with Jim Lehrer and NPR's Talk of the Nation to the Fox News channels O'Reilly Factor and Entertainment Tonight. In 2007, Professor Adler was the Case Western Reserve University Law Alumni Association's annual Distinguished Teacher. And with that, I'm going to turn it over and welcome Professor Adler to what is going to be a riveting presentation today on the Supreme Court. And one last thing, he is the recent author of Business and the Roberts Court. There are flyers outside to get discounted copies on your way out. Thank you and enjoy the class.
Thank you. Thank you for coming out on a Saturday. It's a pleasure to be able to be with you this afternoon to talk about the Supreme Court, and certainly a pleasure to be here for many of you who are here for Alumni Weekend. And I hope for those of you that came from out of town, I hope you're enjoying your time in Cleveland. We're doing our best to make sure the weather's good for you. We have some baseball games. You know, we're trying to make sure Cleveland is performing at its best while you're here. I'm going to talk a little bit about the Supreme Court, try and put it a little bit in perspective. I'm planning on talking for about 40 minutes, 45 minutes, so we have plenty of time for questions. There's a lot in terms of what the court's doing now, what the court might be doing soon, what the court might not be doing soon, that I'm sure many of you have questions about, and I want to leave some time to talk about those things. But I also wanted to spend a little bit of time putting some things in perspective in terms of the court's history, as well as what we've seen on the Supreme Court since John Roberts has been chief. Now, since many of you are back for Alumni Weekend, I figured it really wouldn't be a law-type class if I didn't have questions for you. I won't cold call on people. I don't have a seating chart, but I will occasionally put up some slides that have some questions to test your knowledge of the court. Some of these questions, I think, produce some surprising answers. So we're just talking about the current court. This past year, we had certainly a very interesting term. Does anyone know which two justices agreed the most in the term that concluded this past June? Any guesses? Breyer and Ginsburg. No, it's a good guess, but no, not Breyer and Ginsburg. Thomas and Scalia agreed fifth most. They were the fifth most likely pair. It's generally assumed that they vote together the most. They have not been the most common pairing in quite some time. One more. Thomas and Alito, no, surprisingly enough, not the most common pair last term agreeing on the result in 95% of cases were Justices Kagan and Kennedy. That tells you a lot about the state of the court. That tells you a lot about the balance of the court right now. Not a pairing we see all that often, but that was the most common pairing in the term just concluded. One other question, just on this past term, which justice wrote the most total opinions, signed opinions, majorities, concurrences, and dissents together? Any ideas? Thomas. Thomas wrote 39, which is a lot. In the average term right now, given the number of cases the court decides, each justice will typically write about 8 or 9 opinions. The Chief Justice, like his predecessor, works very hard to try and spread out writing assignments for majority opinions quite evenly, and so most justices have 7, 8, 9 majority opinions. All the rest are concurrences and dissents. Justice Thomas wrote a lot of concurrences and dissents last term, like he has in many of the last several years. This is was the court we had up until February. Our 9 justices on the court. As we all know, there is now a vacancy on the court. We'll say a little bit more about what we might expect from that vacancy when it's filled, and what we can expect and are seeing so long as the court has 8 justices, as also what we might expect when we have a 9th justice, depending, of course, on who that justice is. The court, though, if we look at it historically, has gone through periods of time where it's had 8 justices, where it's had an even number of justices. Before the court was in its current home, when it was first founded, it was very different and operated very differently than it does today. One thing, though, we should keep in mind is that the court, through much of our history, may have been seen as the least dangerous branch, the least prominent branch, but it was an essential part of the constitutional design. If you go back and look at the various arguments that were made about why we needed to replace the Articles of Confederation with the Constitution, one of the defects that the founders identified in the Articles of Confederation was the lack of a federal judiciary, the lack of federal courts in which individuals and states of that lived in different jurisdictions that needed to resolve a question of federal law. There was no federal judiciary that could resolve those sorts of questions. And so when they met in Philadelphia to initially draft what were to have been amendments to the Articles and what became the U.S. Constitution, one of the things they focused on was ensuring that there would be a federal judiciary. And it's also worth noting that one of the complaints that some anti-federalists had about the proposed Constitution was the existence of a federal judiciary. They feared that a federal judiciary would be one of several features of the Constitution that would lead to greater centralization of federal power at the expense of the states. Just on that point, and I'll go through some of this a little bit quickly so we can get to the contemporary stuff, but Alexander Hamilton in Federalist 22 said that a circumstance which crowns the defects of the Confederation is the want of a judiciary power. Laws are dead letter without courts to expound and define their true meaning. There was a concern that a New York court might interpret a federal law or a federal treaty differently than, say, a Virginia court. And one of the early Marshall Court's most important decisions actually involves the appeal of an interpretation of a treaty that had been interpreted one way by the Virginia Supreme Court, and the U.S. Supreme Court thought that had been interpreted wrongly. One of the Marshall Court's most important early decisions, a case called Martin versus Hunter's Lessee, some of you may remember it, is all about this principle that if there's a federal treaty that binds the United States as a whole, there needs to be a single interpretation of that treaty in the judiciary so that that treaty means the same thing throughout the United States. The court began, its first term was in 1790. After the Constitution's ratified, it's organized by the Federal Judiciary Act of 1789. The Constitution provides that there must be a court, there must be a Supreme Court. The Constitution does not require any lower courts. It gives Congress complete discretion about how many lower courts there are. And the Constitution does not specify how many justices there should be. It just merely says that there will be a Supreme Court. The first term of the court was in New York, in the Merchants Bank building. Then after that, its next few terms were in Philadelphia, in what was essentially City Hall, adjoining Independence Hall in Philadelphia, before it moved to Washington, D.C., with the rest of the federal government. It would be a long time, though, before the court would have its current majestic or palatial home to reside in. There was a period of time, in fact, when the court met in the basement of the Capitol. And to compound the indignity of that, there were no robing rooms. So literally, you can find contemporaneous accounts of people coming to the Capitol and seeing the justices putting on their robes in the hallway before going in to hear a case. Quite different from what we expect in courts today. Other thing that's interesting about the early court was its size. When the court was first created and authorized in the Judiciary Act of 1789, it had 6 members. Congress thought that the court needed 6 and that a quorum for reaching a decision would be 4. That's somewhat interesting given that today we are certainly used to having an odd-member court. We're used to having a 9-member court. We're used to appellate courts generally having odd numbers, in part because that prevents deadlocks. But in 1789, perhaps simply because they didn't have much experience with federal courts and experience with deadlocks, they initially authorized the court to have 6 members. As this chart shows, the number of authorized positions has gone up and down in the years since. I included an extra bar for 1937 because, as many of you know, in 1937 there was a proposal to increase, at least temporarily, the number of justices that was put forward by Franklin Roosevelt, but was defeated. I think the other thing, though, this chart shows is that since the end of the Civil War, though, we have had a court that was authorized to have 9 justices. A quorum of the court to decide a case is 6. So if the court does not have a minimum of 6 justices, it cannot decide the case. But we have had 9 justices now for about 150 years. And I think most people think that that is a good number. And having an odd number certainly prevents deadlocks. Justice Ginsburg was recently asked about the appropriate number of justices, whether it should be 9, and she said certainly no more than that. But we're certainly used to 9 justices, but it is just worth remembering that the Constitution doesn't say 9. The Constitution doesn't say an odd number. That's a decision that we've made politically over our nation's history. That's the choice that Congress has made, one that, again, I think most of us think is a good number, but one that is a result of our experience with the federal judiciary and its operations, not something that is particularly mandated. There we go. In terms of our current justices, it's worth noting as well that we have quite a few justices that are probably likely to not be on the court for that much longer. The oldest justice currently on the court is Justice Ginsburg. I have Justice Scalia up there, who died in February at 79, because I'm going to talk a bit about the Roberts Court, and he was certainly an important part of the Roberts Court. I have Merrick Garland up there just so you can see by comparison. He would not be the youngest justice on the court were he to be confirmed. In fact, he would be right in the middle age-wise. There would be 4 justices younger than him and 4 older. But certainly with Ruth Bader Ginsburg at 83, Anthony Kennedy at 80, Stephen Breyer at 78, we would certainly expect that the next president is likely to have the opportunity to nominate replacements for 1, if not all 3 of those justices. So the court is very much in a period of transition, and it's a period of transition that, that we've been going through, I would argue, since 2005. The reason I say that is because between 1994 and 2005, between the confirmation of Stephen Breyer and the confirmation of John Roberts as chief, the court went through the longest period of time in our nation's history of having the same 9 justices. It was a very unusual thing for the court to go 11 years with the same 9 justices. And for people that study the court, they would argue that you actually see changes in behavior of the court when there is that much stability. You know a lot about your colleagues. You know a lot about their preferences, what sorts of cases they're going to want to hear, how they might vote in a particular case, and that influences the way the justices behave. Whereas when you're getting a new member every few years, it may take some time for you to figure out what their preferences are, and we certainly know that often when a new justice comes to the court, it takes a few years for them to fully get their footing. A lot of times, new justices are being confronted with new questions, issues that weren't before them when they were on a lower court, and also a certain degree of freedom as a Supreme Court justice. As a lower court judge, you're very much concerned about what does precedent say? What has the Supreme Court said on this before? How do I make sure I don't get reversed? When you're a Supreme Court justice, there's really no one to reverse you. So the range of questions you can look at, the way you can look at them changes. There's a couple other quick questions just in terms of our current court and their experience. Anyone know which justices were academics? As a professor, I have to ask this question because, Any ideas? We have three: Justice Kennedy, Justice Ginsburg, and Justice Kagan were all academics. The late Justice Scalia had been an academic as well. This may explain the length of their opinions. It may explain the number of questions they ask at oral argument. We do have a significant amount of academic representation on the current court. Which justices were Supreme Court clerks? Roberts clerk for Chief Justice Rehnquist in 1981. And Chief Justice Rehnquist himself had also been a clerk for Justice Robert Jackson. So Roberts had been a clerk. Kagan had been a clerk. Roberts, Kagan, and Breyer had been Supreme Court clerks. Alito had not been a Supreme Court clerk. Which justices were prosecutors? Sotomayor was a prosecutor, and Alito was a prosecutor. We have two justices that were prosecutors. How many were district court judges? Sotomayor, and that's it, which is interesting because, the Supreme Court hears 80 cases a year. How many cases are heard in federal district court? A lot. I don't know the number. I know there are 8,000 cert petitions filed a year, and that's a fraction of appellate cases, and not every district court case results in an appellate decision. There are thousands upon thousands of district court opinions. A lot of what the Supreme Court does actually gets put into practice in district courts. And yet we only have one justice on the court that's actually been a district court judge, sitting there reviewing a motion in limine on an evidentiary question, or looking at a question about whether or not a confession was voluntary, or looking at a question about how we might interpret a certain type of contract term. It's really interesting. There's only one justice that's been a district court judge. Last one, I think, in this set. Which justices were criminal defense attorneys? None. So we've had justices that have done pro bono work at the appellate level on things like habeas appeals, or have done work, again, on the appellate level for criminal defendants. Certainly, those justices that had Supreme Court practices before they were on the court did some of that sort of work. But in terms of actually representing criminal defendants in plea negotiations, in trial court, and so on, there is no justice on the court that has that experience. And if you think about the sorts of things that justices might be sensitive to or not sensitive to in a given case, it's reasonable to think this might have an effect, that there's a lot of intellectual firepower on this court. There's a lot of very significant appellate experience on this court, decent amount of executive branch experience on this court. Two justices that worked for members of Congress. Justice Breyer and Justice Thomas both worked for members of Congress, but no current justice that has been a criminal defense attorney. And that is something that's worth thinking about. In terms of the court, the current court, or the court that we've been looking at for the past 10 years, it's often characterized as a divided court, a court that's riven by divisions, typically along left-right lines. I think this narrative really is unhelpful to understanding the court, because I don't think it actually captures the actual practice of the court. The reason I think we get this impression is because the court's term always ends at the end of June, and those cases that are handed out at the end of June tend to be the exciting ones. That's the abortion cases, and the race cases, and the death penalty cases, and the healthcare cases, and so on. We get those all in a burst in those last week or two of June. And then all the Supreme Court reporters do their annual Supreme Court wrap-up article. And what cases are on their mind? Well, the cases that just came down, the cases that were the hardest, that were the most difficult, and the most likely to produce these sorts of divisions. But they actually represent a small fraction of what the court actually does. So if we look at, and this is probably hard for you to read, but this is data going back to the October term 2006, just a breakdown of the court's opinions by the voting, 9-0, 8-1, 7-2, and so on. The very last bar at the end is what I call 5-4-I. So that's 5-4 decisions that are a lot where the split was what we would characterize as a left-right ideological split, with Justice Kennedy casting the deciding vote. And what you see in each year is that the biggest bar is the 9-0 bar. that the lion's share of cases every term are unanimous. And a decent number are typically 8-1 or 7-2. For this last term, for the most recent term, I put the 4 cases that were split 4-4. I treated those as 5-4 cases because they would have been 5-4 had there been a ninth justice. One reason that I think one reason I think this data is even more remarkable is that something else that we've seen on the court over the last 30 years is a much smaller docket. So this is a plot of the Supreme Court's docket from 1980 to 2012. In 1982, the court would hear 151 cases. Now it rarely hits 80. It'll hit 80 maybe if you include the 10 or so cases that are summary reversals, cases where the court reverses a lower court with a written opinion but without oral argument. So that, the case is just so wrong or what have you, they just say, try again. They do about 10 of those a year. Only about 75 cases a year get oral argument. That's half of what the court was doing 30 years ago. What accounts for that? Well, one thing that accounts for that is the court's mandatory jurisdiction has shrunk. Congress shrank the percentage of cases or the types of cases that the court had to hear. So that's a tiny percentage of the court's docket now. Almost all of the court's docket are discretionary cases. Cases where someone's filed a petition for certiorari and the court has the choice, do we want to hear this? And the court's become pretty stingy about the cases it hears. And if you look at the cases it hears, it, for the most part, only hears cases that have divided lower courts. They hear a handful of cases in which a lower court has struck down a federal law. That's something that the court independently views as cert-worthy if a lower court has struck down a federal law. But 80–90% of the cases are certiorari cases. Vast majority of those are cases where lower courts have split. Well, what does that mean? That means that very intelligent, very thoughtful lower court judges, with the benefit of briefing, perhaps even the benefit of seeing what other courts have done, have nonetheless disagreed. So the selection of cases the court gets now, more than ever, are the hardest, closest, most difficult to resolve cases in our legal system. And given that, I would think we would expect more 5-4 decisions, because these are decisions that circuits are disagreeing upon. These are cases that state Supreme Courts are disagreeing upon. And yet, despite those disagreements below, the fact that 30, 40, in some years even 50% of the cases they hear are decided unanimously suggests something I think that's quite significant, that even with the divisions we see on the court actually does not naturally tend towards splitting ideologically. It actually tends toward a greater degree of unanimity. And if you just simply do a simple line plot, do a running 3-year average of a simple linear plot of the trends, the upper bar is the trend of percentage that's unanimous, and the lower bar is the percentage of trends that are 5-4. Since John Roberts has been chief, the percentage of the court's decisions that have been 9-0 appears to have been increasing. The percentage of decisions that are decided 5-4 is decreasing, again, despite the fact that they are taking fewer cases, and as a consequence, taking the most difficult cases to decide. We've called the court the Roberts Court a lot, and we may, depending on what happens in the election and what happens with the next confirmation, assuming there is one, may have to think about whether we refer to it as the Roberts Court. But when looking at the last 10 years, I think there are some things about the court that definitely bear the Chief Justice's imprint. He certainly prides himself and thinks the court should focus on narrower opinions with broader unanimity. He said that in his confirmation hearings. That's something that I think he has been surprisingly successful at doing in the majority of cases, moving the court towards narrower holdings in most cases and broader holdings. So that's certainly something that we would have expected from him as chief, something that I think he's been somewhat successful at. That said, I'm not sure we should necessarily refer to the court as the Roberts Court if we actually want to understand what it's doing, especially in the cases that we most care about. The court often splits left-right, and in those cases, it's Justice Kennedy who's in the middle, not Chief Justice Roberts. If there's an issue that makes the front page of the newspaper and you want to know how it's likely to come out, chances are you want to know how Justice Kennedy feels about it. Because Justice Kennedy, more than any other justice on the court, is likely to be in the majority. Justice Kennedy's somewhat idiosyncratic view of constitutional issues in particular really can be seen in the decisions that the court reaches. One other division I should just note on the court, though, that's important, and one that I think will be increasingly important in the years to come, is what we might refer to as a formalist versus pragmatist split that's most notable in cases involving criminal procedure. And the way to understand the split is as follows. The formalists are folks that like bright lines. They want a clear standard. The pragmatists are the ones that think, well, things are difficult. So, give an example. Someone's being criminally charged, and there is a forensic report that maybe it's DNA evidence or blood evidence or something, and the Constitution says you have a right to confront the witnesses against you. Does that mean you have the right to question the person that performed that report? Do you have the right to confront that person? Or is that kind of difficult? In a state like Montana, the lab may be across the state. Well, in those sorts of cases, there's generally, over the last 10 years, there have been 5 justices, some liberal, some conservative, that have said we have specific rights guaranteed in the Constitution. They don't include in them any kind of qualifiers about what's pragmatic or what's easy for the state to do. We have to enforce that. And you've had 4 justices, again, some on the right, some on the left, that say, no, these cases are difficult. We have to think about the practicality involved. And that's what's been very important in criminal procedure cases. It's a reason why Justice Scalia, if any of you do criminal defense work, is recognized as being simultaneously the best and the worst justice for criminal defendants. The worst because he has a very narrow view of, for example, had a very narrow view of the exclusionary rule, but the best for criminal defendants in that he has been the most aggressive and forceful in arguing that if there is a right in the Constitution that criminal defendants are entitled to, it must be enforced without exception. And so we've seen that in confrontation clause. We've seen that in the jury trial right and the like. That's something that we don't pay as much attention to as left-right splits, but something that's very important and will certainly be affected by whoever the next justice is. Talking about the last term, which justice was in the majority the most? I think you all can probably guess this. Kennedy, right? So he was in the majority 98% of the time. Dissented, I think, once. Which justice was in the majority the least? Any ideas? Thomas. It was Thomas. 72% of the time was the amount of time he was in the majority. So note, right, every justice was in the majority over 70% of the time. The question is, did you dissent 2% of the time like Justice Kennedy or 28% of the time like Justice Thomas or somewhere in between? Again, another reflection of the fact that day in, day out, the court is actually agreeing on quite a bit. Just something else on the Kennedy court. Again, this is probably too small to read, but in the last 8 years, Justice Kennedy has been the majority the most, all but 2 of the years. So, just year in, year out, he is in the majority more than any other justice, or once or twice he was the second most, once or twice he was tied. But he's the guy that's in the majority. If you want to understand what the court's been doing, you want to understand him. If you're arguing a case before the court and you expect it to divide the court, that's the justice you need to be focused on and need to be talking to. In terms of what that means for the court, it's really kind of interesting because there are some issues on which Justice Kennedy is certainly a conservative justice, and there are some issues on which he's not particularly conservative. So in criminal procedure, generally, he's conservative. He's not a huge fan of the exclusionary rule. He is a pragmatist in these pragmatist formalist splits. He thinks that we shouldn't impose rules that make it too difficult for prosecutors and for police to do their jobs. He's been conservative on federalism. He has often been a vote to restrict the scope of federal power. He's often been a vote to restrict tort litigation, whether that's voting to increase the requirements for pleading standards, a vote to enforce preemption under the Federal Arbitration Act, or a vote to hold that there are constitutional limits on the size of punitive damage awards. He's also been a conservative justice on the First Amendment in that he has tended to vote in favor of protecting that sort of speech that conservatives tend to like, campaign finance, commercial speech. But he's also been a fairly liberal justice on some issues. He's been quite liberal on the Eighth Amendment, voting to restrict the applicability of the death penalty fairly consistently. So for example, voting to say that it is unconstitutional to execute somebody who committed a non-lethal offense. So there were some states and even the federal military, US military had statutes that would make child rape, for example, a capital offense. Kennedy was the deciding vote in saying that that's unconstitutional. He has a broad conception of liberty interests that have led to his votes and opinions in cases like Lawrence versus Texas, which struck down the same-sex sodomy law of the state of Texas, his votes in Windsor and in Obergefell on gay marriage. He has this notion of a realm of personal autonomy and personal dignity that should be beyond the reach of the state, which has often led him to vote with the more liberal justices. He was the deciding vote in a very important executive power and national security case called Boumediene. This case involved a challenge to the Detainee Treatment Act and Military Commissions Act that Congress had enacted, a 5-4 case, the most single aggressive exercise of judicial review of a wartime or national security measure in our nation's history. And that's just a descriptive statement. I mean, we may think that's great, you may think it's terrible. The point is, as a historical matter, it was a dramatic break from most of the cases we'd seen in the past where the court had been fairly deferential to the political branches when they would assert the need to do things for national security. And then in the First Amendment context, Justice Kennedy again is the most protective justice of the speech that's most important to liberals. He is a consistent vote against statutes that might criminalize expression that's considered obscene or extreme. Justice Kennedy, in fact, is the most speech protective justice on the court, and it's not particularly close. If you have are involved with a statute or there's a case involving a restriction on speech of any sort, chances are you will not have Justice Kennedy in your majority. And what's interesting when you look at these areas where Justice Kennedy is conservative and liberal, because he's almost always in the majority, this describes the Supreme Court we've been seeing for the last 10 years. It's been conservative where Justice Kennedy is conservative. It's been liberal where Justice Kennedy is liberal. That's why some of us would say that we call it the Roberts Court, but in some respects, it's really been the Kennedy Court because it's Justice Kennedy's particular view of a lot of these issues that has controlled the outcome. And so similarly, we want to talk about, has the court moved right under the Roberts Court? It's the same sort of thing in areas where Justice Kennedy's been willing to move the law to the right. We've seen that. We've seen that in antitrust law, where the court has not universally, but quite consistently voted in favor of defendants in antitrust cases, protecting campaign-related speech like in Citizens United, narrowing pleading standards in cases like Twombly and Iqbal, in the Fourth Amendment in terms of exceptions to the exclusionary rule. Justice Kennedy has certainly joined other justices, the other conservative justices in narrowing that. For those of you that do any work on habeas or who follow the Sixth Circuit, Justice Kennedy has been a fairly frequent vote to overturn lower court decisions granting habeas petitions. We've had quite a few of those in the Sixth Circuit. And Justice Kennedy has joined the conservatives in saying, no, we're going to read AEDPA very, very narrowly. But in terms of areas where the law hasn't moved right, I already mentioned war powers, the Eighth Amendment, offensive speech, standing, an area where both Justice Scalia and Chief Justice Roberts really wanted to narrow Article III standing, make it more difficult for people to sue in federal court, especially against the federal government. They've been largely unsuccessful at that thus far. Justice Kennedy has not consistently joined with the conservative justices in trying to restrict standing. This last term in particular, or the 2 terms ago, obviously gay marriage recognized as a constitutional right, but in the last term in particular, on questions of both race and abortion, Justice Kennedy refused to join with the more conservative justices to move the law in a more conservative direction. This is most significant, I think, in the Fisher case, the case involving the Texas affirmative action plan for the University of Texas. That was the first time Justice Kennedy had ever voted in favor of a government policy that considered race in decision-making. Up until the Fisher case this past term, he had voted against the permissibility of considering race in every case that had come to the Supreme Court since he had been on it. And I think it's significant that he was the fifth vote the fourth vote. It would have been fifth if Justice Kagan hadn't been recused, but he provided the deciding vote in Fisher. And then in the abortion decision this past term as well, we can debate whether or not it maintains the status quo of the Casey decision from the mid-'80s, or we could suggest that it maybe made it more difficult for states to enact restrictions on abortion. Either way, what's clear is that since John Roberts has been Chief Justice, the Supreme Court, despite expectations that it would eventually further curtail the constitutionally protected abortion right, it has not done so. And certainly folks that work in this area think that there's a lot in the whole women's health decision from this past term that will actually make it easier going forward to challenge various state law restrictions on access to abortion. So another area where the court has not moved right since John Roberts has been the chief. So we're going to talk about the Roberts Court up till now. I always say it's a conservative minimalist court, except when it's not. What I mean by that, for those of you that are, that are kind of quantitative in orientation, the modal tendency of the court is what I would characterize as a conservative minimalist outcome. That is to say, in most cases, the court is deciding things very narrowly, and if there's a left-right valence to the decision, chances are it will be slightly to the right. The except when it's not is because there are these cases, they're often very high-profile cases, some of the ones on the last slide, where the court is neither particularly conservative nor particularly minimalist. The modal tendency of the court, I think that is the influence of the Chief Justice. That's something he's put a big priority on, narrow decisions, small steps, don't decide more than you have to, but the except when it's not part, that's Justice Kennedy. Because when Justice Kennedy really feels strongly about something, he doesn't care about small steps. Whether or not it's conservative or not, well, that depends on the issue. And so we can see that. So, for example, a case like Citizens United, that's a Justice Kennedy opinion, right? That's all the way down. He cares very strongly about all speech and expression. He cares just as much about government restrictions on the ability to spend money for and against candidates as he does about whether or not the government can outlaw crush videos or make it a criminal offense to lie about your military record or what have you. He generally is just very hostile to government restrictions on speech, and he feels no need to do it little by little. In fact, Jeff Toobin, who some of you may be familiar with, a reporter with the New Yorker, wrote a story about Citizens United, which others have confirmed, which said that initially when that case was argued, Chief Justice John Roberts took the opinion for himself and was going to write a very narrow opinion that would have exempted the video in question from coverage of the law, but left the law intact. And according to Toobin's reporting, Justice Kennedy said, no. You know, the statute says this is what it covers. An on-demand video is a communication that's covered by the law. It's about a candidate. For those of you that don't remember, it was a video produced by this group, Citizens United, critical of Hillary Clinton. They wanted to make it available on on-demand cable television in the weeks before the election. Justice Kennedy said, no, I read the statute. This is covered. He thought it was outrageous that the government could criminally punish disseminating critical information about a candidate prior to an election. And so he apparently wrote a concurrence that was, First Amendment, First Amendment, First Amendment, strike the whole law down. And that opinion circulated, and apparently Justices Alito, Thomas, and Scalia looked at the Roberts opinion, looked at the Kennedy opinion, liked the Kennedy opinion, and Roberts suddenly saw himself being by himself, being the only justice on the court willing to say that the video wasn't covered by the statute. Because 4 justices were going to say it's covered and that's not a problem, and 4 were going to say it's covered and that's a real problem. And at that point, according to this account, Chief Justice Roberts acquiesced, decided it was better to have a 5-4 decision than a 4-1-4 decision, and then the court agreed to hear the case for re-argument purely on the constitutional question. That kind of account squares very much with what we know about Justice Kennedy. When he cares about an issue, there is nothing modest or minimalist about his opinions. He's going to embrace that principle, and it will be quite broad. And if you look at his opinions in cases like Obergefell or Lawrence versus Texas, there are often these passages that sweep quite broadly that are very much a part of Justice Kennedy's jurisprudence, whereas Chief Justice Roberts' opinion often says nothing more than what you need to decide that case, which can obviously be very frustrating if you have a case that's very similar to the case that was decided, but not quite on all fours. I want to say a little bit now about what we can say about the court now that it has just 8 members. This past term, there were 4 cases where it split 4-4. Not a large number, but certainly cases that people cared about. The immigration case, a case involving dues for public sector unions, and the fact that the court is split, it only has 8 justices right now, is certainly affecting the way the court is operating at the moment. One thing, and this is a chart I pulled from a website called SCOTUS blog. Some of you may be familiar. They put out a regular statistical analyses of the court. And this is kind of hard to see, but the yellow line is the rate at which the court has been accepting cases for this term. The black line is the average number of cases the court has accepted over the last 5 years, over time. So, and the gray bar is the summer recess. So you can see that the yellow bar is below all of the lines and significantly below the average of the number of cases that the court has taken. The court is taking fewer cases. It's taking a lot of intellectual property cases. It doesn't do that very much, but it's taken a bunch of those. So if you practice intellectual property, the court's going to be doing a lot for you or to you this year. But the court's been very reluctant to take cases, and it's certainly reasonable to make 2 assumptions about that. One is, for the court to take a case, you need 4 votes. It takes 4 votes to grant certiorari. And so if you're trying to get 4 out of 9, that's obviously easier than getting 4 out of 8. There's 1 less justice to be that 4th vote. But I think the other factor is the court is reluctant about taking cases that might produce a 4-4 split. And there might even be some strategic behavior in the sense of justices might want to be more likely to take a case if they think it will come out what they think is the correct way. And not knowing who the 9th justice is, that's hard to tell. Something else that's really interesting is not only is the court taking fewer cases and taking them at a slower rate, it's scheduling cases at a slower rate. So there are some interesting cases the court has accepted for this term. There's an interesting religious freedom case involving whether or not a church can get state-subsidized rubber for a playground. It's actually a really interesting case. Some cases involving challenges to redistricting in Virginia and North Carolina that raise really difficult questions about what's permissible versus impermissible consideration of race and partisan factors in districting. Those are accepted for this term. They haven't been scheduled. And they've been scheduling other cases. They haven't scheduled these. And given that the court usually schedules cases more or less in the order they accept them, it's reasonable to believe that the court is hoping that it has a 9th justice to hear those cases, and that's why it hasn't put them on the schedule yet. President Obama has nominated someone for this 9th spot, Judge Merrick Garland, a very distinguished judge on the U.S. Court of Appeals for the D.C. Circuit, the chief judge of that court. He was initially nominated by President Clinton. I clerked on the D.C. Circuit in 2000, 2001, so I got to know Judge Garland a little bit, which means I remember him. I'm certain he does not remember me. Very distinguished, very well respected judge. There are some interesting things about him just in terms of thinking about what his likely effect would be on the court, and how he might differ from Justice Scalia. Certainly on questions that we tend to think of as being ideological questions or political questions, questions that divide the justices along liberal conservative lines, it's reasonable to expect that Justice Garland would be a liberal on most of those issues. I say reasonable to expect because on the DC Circuit, he's written opinions in surprisingly few cases involving hot button issues. And it's really remarkable given how long he's been on that court, how most of his opinions are kind of dull. The DC Circuit generally has a docket, which is, I admit, something of an acquired taste. It's a taste that I have. I love these regulatory cases that are the lion's share of its docket. My wife thinks that they are insufferably dull and boring. So I think some of these cases about, like, you know, the appointments clause or, you know, what's the contours of arbitrary and capricious review are really cool. Not so much most folks. But even apart from that, on the DC Circuit, Judge Garland rarely dissented. His rate of dissents is about 1 per term, which is low. I mean, there aren't a lot of dissents on the DC Circuit, but most judges maybe dissent 2 or 3 times a term. Garland less than that, would write separately in concurrences even less than that. So we don't know as much about Judge Garland as we might about someone who had lots of cases on hot button social or political issues. But we can say some things about him, both based on, at least on his record on the DC Circuit. He has been a fairly consistent vote in favor of the government in criminal law cases, and he's a former prosecutor. So I mean, we would have yet a 3rd prosecutor on the court if he were confirmed. It's rare to find him voting to suppress evidence, to decide something was an unreasonable search, and the like. Similarly, in habeas cases involving enemy combatants, the DC Circuit now has exclusive jurisdiction on habeas appeals out of Guantanamo, pretty consistently voting in favor of the government in those cases. And in regulatory cases, he's almost never dissented or been on the anti-agency side in a case that's divided the court. So when there's been a 3-judge panel that's split over a question of whether a government agency could issue a given regulation or impose a given enforcement action, if that issue split the 3-judge panel, he has almost invariably been on the side in favor of the government agency. And that's been true when you've had Democrats in control of agencies as well as Republicans. So this is not, oh, he's always voted for the Obama administration. He's just, on the DC Circuit at least, has been a fairly deferential judge when it's come to these sorts of cases. I highlight these cases because these are areas in which Justice Scalia has sometimes been uncharacteristically liberal or unconservative. Right? So in a lot of criminal law cases, Justice Scalia has been quite protective of criminal defendants' rights. He wrote the opinion saying that heat detection devices constitute a search under the 4th Amendment. He very outspoken in saying things like GPS transponders on vehicles can be searches, or consistently saying that we have to understand the meaning of a search under the 4th Amendment in light of modern technology. Voting consistently to read the Confrontation Clause and the jury right and so on by their express terms and not admitting exceptions to those. If we had to guess, that's an area where Justice Garland would likely be very different, and where Justice Garland would be quote unquote more conservative than Justice Scalia. So we would expect Justice Garland to perhaps be more liberal on issues perhaps relating to sexual liberty, race, things like that. But likely to be less sympathetic to criminal defendants' rights than Justice Scalia. Also, if I had to make a prediction, less likely to question some of our deference doctrines that apply to regulatory agencies than Justice Scalia. Justice Scalia, especially in his last few years on the court, had started to express misgivings about the extent to which courts show deference to regulatory agencies, even questioning one of his own prior opinions in a case called Auer, A AEUR or AUER. Anyway, it's Auer deference, Auer versus Robbins, otherwise known as Seminole Rock deference. Question of deference to a agency's interpretation of its own regulation. Justice Scalia had written several opinions saying that that actually is problematic. No reason to think that a Justice Garland would share those views. So those are some areas that are perhaps not as obvious as the traditional left-right areas where we would expect a Justice Garland to be different than a Justice Scalia. If he were confirmed on the court, the other thing I think we would just in terms of the left-right split, I think that this would kind of be the spectrum we would expect. Justice Thomas and Justice Alito being the most conservative justices, Sotomayor and Ginsburg being the most liberal, and that the middle of the court, I think, would really be Justice Breyer or somewhere related to Justice Breyer and Justice Kennedy. Justice Breyer has often been a sixth vote with the more conservative justices on some criminal justice issues, on some issues relating to review of agency action. He also joined the conservative justices in parts of the NFIB versus Sebelius healthcare case. So that's where I think we would expect the center of gravity of the court to be if Justice Garland were confirmed. On the formalist versus pragmatist split, I think I've already said this. There's no reason to think that he would be on the bright line. We don't carve out exceptions to enumerated rights of criminal defendants side of that split. I think he'd very likely be on the side of adopting a more pragmatic and deferential approach in those sorts of cases. I think I just have a couple more. And just in terms of the current term, the court has accepted some interesting cases. There's a fun commercial speech case. I should say as a disclosure, I was part of an amicus brief that urged the court to take this case involving whether or not it violates the First Amendment to allow or to prohibit companies from charging surcharges on credit card transactions while allowing them to offer discounts for cash transactions. So the argument is that the law in question economically allows you to have different prices for credit cards versus cash. The only thing it prevents you from doing is characterizing it as a surcharge as opposed to a discount. And so the only thing that's actually being regulated is speech. That'll be a very interesting case. There's a juror bias case that was just argued this week. Traditionally, we are very, very protective of what goes on in the jury room and very reluctant to have courts ask about what occurred. There's a case in which evidence emerged that a juror said some things during the jury deliberations that were premised upon pretty crude and offensive and outrageous racial stereotypes, and that this appears to have convinced the jury because the individual was also was a former police officer. So the court is being asked the question: is this egregious enough that the sanctity of the jury room and jury deliberations can be questioned in this sort of case? Really interesting case because we generally think that that's just something we don't look at. I mentioned the case about whether the church can get a government-subsidized rubber for its playground. It's a state law in Missouri that says you can't directly subsidize or directly fund church institutions or religious institutions. It's a state constitutional limitation, and the question is whether or not that either constitutes a violation of the Equal Protection Clause or is a penalty on religion in violation of the Free Exercise Clause. There's some redistricting cases that are really fascinating, really difficult. There's also a very interesting regulatory takings case, which could be quite significant. It involves what people that do property law refer to as the denominator problem. So the question is when the government is doing something that restricts your property and reduces its value, if you're thinking about, and you know that under Lucas, if the government wipes out all the value of the property, that's a taking. But if it wipes out part of the value, we do this complicated balancing test that the government almost always wins. And so here you have a case where you have two parcels that are next to each other that were purchased separately, but owned by family members, that the state considers to be one parcel. And so one of the parcels has been developed, one hasn't. The state's saying you can't develop the other parcel. The property owners are saying you've effectively taken all of the parcel we can't develop. The state's view is no, you own two, and we're only preventing you from developing on half. So we've diminished your value by half. We haven't taken all of it, and so the court is being asked to resolve this really important question because determining what the size of the property is or the value of the property is against which a taking is measured is really important. So that's another case that the court has taken. I said I'd only talk for 40 minutes. I've gone longer than that. Whole bunch of cases happy to talk about that the court could get to the court this term or next term. The immigration case could certainly come back. The case that was decided last term was on appeal of a preliminary injunction. So the appeal of the ruling on the merits certainly could come back to the case. There's some voting rights cases. We've had some in Ohio that I don't expect the court to take, but there are some from North Carolina where I think the court is likely to take some cases involving voter ID. There's some cases relating to agency deference. The Clean Power Plan involving control of greenhouse gas emissions is currently before the DC Circuit. That is certainly a case that could be before the court in the next year or so. WOTUS, we have POTUS, and we have FLOTUS, and we have SCOTUS. WOTUS is Waters of the United States. For those of you that do environmental law, very important issue. There's currently a mess of litigation involving the regulations defining what constitutes a water of the United States. There are some interesting procedural questions that I think the court might take this term, and then eventually substantive. And then the last thing, healthcare reform. Some of you may have heard me say this before, but the Supreme Court's not done with healthcare reform. It's had 4 Affordable Care Act cases thus far. It's going to have many more. There are several in lower federal courts right now. There are more that will be filed. It's only a matter of time before we get more of these cases. If it's not this term, it will be shortly thereafter. So I will stop there, and then I'll take questions until James tells me I'm supposed to stop. So thank you much. It varied. I mean, subject matter-wise, I don't think it's had a huge effect. I mean, right now, most of the mandatory jurisdiction are things like election-related cases. So what Congress has done is, in a lot of laws relating to elections, they create a provision that where the initial challenge is before a 3-judge court, usually made up of both district and circuit courts, and then there's a direct appeal. And it is characterized as a direct appeal, so that's the court's appellate jurisdiction. I don't recall all the other specific types of appellate jurisdiction that Congress had identified, but Congress in the 80s decided that in elections you want election-related litigation to finish quickly, because the last thing you want is what we're seeing this year, where you're having month-out cases being decided, and so Congress has left it in place for things like that. But there are very few of those sorts of cases. The other thing that you get in the court's jurisdiction that's somewhat unique are original jurisdiction cases, which are all state versus state, and the court gets 1 or 2 of those a year. They're usually about something like water. So there was a Wyoming versus Montana case a few years ago. There's litigation now involving Georgia and I think South Carolina, and those are part of the court's original jurisdiction under Article 3. So it takes those directly. It then typically assigns a special master to deal with all the fact-finding, because the justices don't want to do that. And then they have special procedures for dealing with challenges to the facts of those. And that's 1 or 2 cases a year. They're usually not very exciting. Well, he did ask a question this year. Actually several. I mean, it was he actually, kept at the end of oral argument, kept the attorney up for an extra 5-6 minutes back and forth. He's given several reasons. But so first, we should put it in historical context. The current court, in terms of number and volume of questions, is unprecedented. In the court's history, especially once oral arguments became relatively short. I mean, you go way back, oral argument would last 4 days. I mean, literally. I mean, it's 150, 200 years ago. But when the court kind of adopted the more modern practice of relatively limited oral argument, it was quite common for advocates to be able to get up and for 10, 15 minutes at a time, speak without interruption. A lot of justices on the Warren Court, Justice Brennan, for example, rarely asked questions. That really changed with Justice Scalia. Justice Scalia, when you look at just monitoring number of questions and so on, radically changed the dynamic of oral argument in terms of the volume of questions, the pointedness of questions, the aggressiveness of questions. And since Justice Scalia came to the court, that pattern has only magnified. And so, Justice Ginsburg, Justice Sotomayor, both very, very aggressive questioners. So that's just some historical context that I think, what we're used to now is actually not the historical norm in terms of the amount of questioning. Justice Thomas, when asked, has often said things like, does anyone think there aren't enough questions? He's generally said that he thinks that there's value in letting the advocates say what they want to say, that given the quality of the briefing, there's, that the issues are typically fairly clear, and that it's rare that a question that he would have doesn't get asked. And, if you listen to the audios of oral argument, and I will confess, I listen to all of them. I have a long commute, so that's my excuse. But either that or I'm just more of a dork than I'm willing to admit. But, the justices trip over each other asking questions. I mean, so that's what he said. In the one case where he asked a bunch of questions this term, there were no other questions. The attorney was getting ready to sit down, and there was a related issue that no one had asked about. And he said, well, no other questions. No one's talked about this. I want to hear about this. So that's what he said. Would it be nice for him to ask more questions? Sure. I think we learn a lot from justices asking questions. But it's not as if there aren't, tons of questions now, and they often even lead to oral argument going over. So that's what he said. I think his practice has been consistent with the reason he's given.
Assuming that a justice wanted to make a statement about current events in society, and choose all the football players and it's a question or an issue that might come before the court, and she did that.
A justice did, yes.
So what is your opinion on that? Why did she ever do it before? Why is she doing it now? What are the other justices? What would be their considerations?
So the questions about recent comments by Justice Ginsburg that have attracted a controversy. And let me say a couple things. One is the justices generally are more public than they historically were. They write books, they give lots of speeches. Justice Ginsburg has also, since she's been on the court, been, I think most people that have actually followed this sort of thing would say the most outspoken in terms of the content of what she says. And this summer she said some things, in particular the comments I think she made over the summer about the presidential election that most observers think were not appropriate for a sitting member of the judiciary to say, given what we generally understand to be the Code of Judicial Ethics. Now, the Code of Ethics for federal judges is imposed on the lower courts. It has never been formally really imposed on the Supreme Court, and we've never really had a situation where we've tried to, because there are separation of powers questions about, can Congress do something more directly? So the court generally is the judge of its own ethical concerns. The justices themselves decide whether to recuse in a case. The justices themselves decide if they need to apologize or walk back remarks. And again, as I mentioned, Justice Ginsburg did apologize for some of the remarks she's made both over the summer and then her most recent interview. My own view is that justices should not say anything that relates to something that could come before the court. But that it's certainly reasonable to talk about things that already have come before the court in which decisions have been issued. So when a justice, let's say, gives a talk at a law school and talks about their judicial philosophy, as Justice Breyer has done quite frequently, as Justice Scalia did quite frequently when he was a justice. I think that's good. I mean, I think that's it's useful for the public to be able to hear a justice talk about why they did something that they already did. But I think it's important that they not cross the line into talking about things that the court has not yet decided. So, for example, Justice Scalia, several years ago, in his speech, when asked about some things related to the Establishment Clause, was asked about that issue generally and made a comment about the reference to under God in the Pledge of Allegiance. It so happened there was a case in the lower court involving whether or not the use of the phrase under God in the Pledge of Allegiance was an Establishment Clause violation. The case did come before the court, and he recused, which I think was entirely proper for him to do so. It would be better for justices not to say things that could require them to recuse. And so just to give what some people might think is maybe a nightmare scenario, if we were to get Bush versus Gore type election litigation this year, based on the comments she made, I think Justice Ginsburg would be obligated to recuse herself, and it would be highly problematic if she did not. Now, I don't expect us to have that kind of litigation. I don't expect it to be hinging on one justice's vote. And I certainly hope that's not the case. But what that indicates to me is that justices just need to be a little more careful. If she wants to talk about her career as an attorney, which is a remarkable career, there's a new children's book which my mother bought for my 9-year-old daughter, which is she's an impressive person. There's a lot for us to learn about her experience, about what influences her decisions and her approach to cases. But I would hope that she, like all the justices, would be careful about limiting public remarks to those sorts of things and not talk about things that come before the court, because the court's standing as an institution depends upon our having faith in the fact that whether we agree with them or disagree with them, that these are 9 very smart, very careful individuals who are trying their best to deal with very difficult problems. And the more they say or do that suggests that they're falling short of that, the harder it is for the court to make the really tough cases when we really depend upon it to resolve a really difficult question. And so, hopefully, all the justices heed that going forward. I think I have time for one or two. You tell me. 2. I'll keep my answer shorter. Right here. I'm not sure about that. I mean, I do think that the court historically has been reluctant to take cases in areas like patent law and in certain areas relating to regulatory process where you have lower courts with specialized dockets that have a level of expertise that the Supreme Court doesn't have, right? So for a long time on questions of patent law, the Federal Circuit was the last stop. The Roberts Court's been more aggressive in reviewing the Federal Circuit than the Rehnquist Court had been. And so I do think the Federal Circuit's comparative expertise definitely was part of what was going on. The idea that, and the same thing with the DC Circuit and a lot of regulatory cases, right? The DC Circuit sees these cases all the time. They know what they're doing. We see 2 a year, and they're really complicated, and our clerks have no idea what to make of them. So I do think there's a little bit of that. I think in general, though, across subject matter, the court really does like to see multiple lower courts taking a swing at a problem. They like not only a circuit split, but they like the benefit of seeing what other judges have done and letting those cases kind of sit and ferment a little bit, because they do think that helps them decide cases. And I think they're probably right. I mean, in the sense that seeing how multiple courts and multiple judges have dealt with a similar question in slightly different factual circumstances, I think helps. And so I think you often see cases where they know they're going to deal with an issue eventually, but figure if they can wait a little bit, they'll have more to go on and are more likely to get a correct decision. So one last one, and then we're gonna. Or is it a human institution? Yes. Do you think that Garland's personality would fit? Would he mention moral against frugality or So, from having clerked on the DC Circuit when he was there, knowing quite a few of the judges there, his reputation in terms of as a colleague is impeccable. I mean, he is universally well-regarded and well-liked. For those of you that know the history of the DC Circuit went through a period of time, especially in the 1980s, and late 70s and 1980s, where it was a lot more like the Sixth Circuit has been at times, in terms of the judges really not trusting and liking each other. The DC Circuit has not been that way for the last 10 or 15 years, for sure. And he's certainly respected as someone who is incredibly smart, incredibly thoughtful, incredibly diligent, and I certainly think he would command the respect of his colleagues. I would not think he would be. I would certainly think he would have some influence in that regard. Well, anyway, thank you all for making the time today.